down a little bit here. We would like to, if everyone's taking their seats, we would like to welcome everyone to EAC's annual Constitution Day celebration. My name is Var Jensen. I am from Glover, Arizona, and I am the president of the Associated Students of Eastern Arizona College. To start off, I would like to first give a big round of applause to the EAC Gila Monster Band under the direction of Justice Bain, who has provided us with our good music. And then I would like to recognize the dignitaries on the stage here. We have EAC board members, Chairman Jeff Larson, and thank you guys. And members Lois Ann Moody, Tina McMaster, and Vince Cooper. And then we have our very own President Todd Haney. Over here we have our Vice President, Susan Wood. And we have another Vice President, Heston. Welcome. And then we have our Chief Government Relations Officer, Keith Alexander. And Heather Floyd with Valley Telecom. And then we have our special guest, Arizona Supreme Court Judge Justice Clint Bullock. We will get started by the EAC Gila Monster Band will now perform the national anthem, after which ASEAC Club Coordinator George Johnson will lead us in the Pledge of Allegiance. Now please stand for the Star Spangled Banner and the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, guys. We are now honored to hear from EAC Vocal Jazz performing We the People by Derek Johnson under direction of Associate Professor Marlene Decker and Patty Raines. There we go.
shining, 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 sing. To shining, sing.
Thank you so much. That was spectacular. I love that. It is now my pleasure to introduce EA's President Todd Haney. President Haney became a college 22nd president on May 16, 2018. President Haney plays an active role in shaping higher education at the local, state, and national levels. He recently served as the chair of the Arizona Community College Coordinating Council, is a board member of Higher Education Research and Development Institute, and is the commissioner for Western Interstate Commission for Higher Education. He serves many roles within the community, but he considers the role of husband and father his greatest responsibility. Please join me in welcoming President Todd Haney.
Ladies and gentlemen and students of Eastern Arizona College, every September, Eastern Arizona College commemorates Constitution Week and Constitution Day, which is tomorrow, September 17th, by inviting guests to come and speak to our campus, to you, and to our community. And ladies and gentlemen, short of getting one of the original signers of the U.S. Constitution here, we are truly honored to have Arizona Supreme Court Justice Clint Bullock here to speak to us today. He is a distinguished jurist whose career has been deeply rooted in defending the principles of the U.S. Constitution. Justice Clint Bullock was appointed to the Arizona Supreme Court in 2016 and retained by voters in 2018. Before joining the court, Justice Bullock litigated constitutional cases across the country, including before the United States Supreme Court. His work is focused on core constitutional principles such as school choice, private property rights, freedom of speech, and federalism. He has also taken on cases challenging racial classifications and government subsidies. Justice Bullock previously served as Vice President for Litigation at the Goldwater Institute and co-founded the Institute for Justice, where he also served as Vice President for Litigation. He holds a Juris Doctorate from the University of California at Davis and a bachelor's degree from Drew University. In addition to his judicial work, Justice Bullock is a prolific writer, having authored 12 books and hundreds of articles. His recent titles include Immigration Wars, Forging an American Solution, co-authored by with former Florida Governor Jeb Bush, and David's Hammer, the case for an activist judiciary. Justice Bullock is a dear friend of Eastern Arizona College, and it's my pleasure to welcome him back to campus. Please join me in welcoming Arizona Supreme Court Justice Clint Bullock.
Wow, what a generous introduction, what a generous welcome, and what a delightful way to kick off the celebration. The marching band was fantastic, and I have to say, I have never heard the preamble to the Constitution set to music. That was awesome. So please join me in giving another round of applause to the marching band and to the wonderful singers that we just heard. What a pleasure to be here today. Yesterday, I was able to cross a very important item off my bucket list. And I know most of my distinguished colleagues on the stage here know exactly what I'm going to say. At long last, I was finally able to eat ice cream at Taylor Freeze. So my wife who is a member of the legislature, she was here several years ago, and she was running for statewide office at the time, and she told me about this wonderful ice cream place in this wonderful town where she was greeted so warmly. And then she came back and she gave the Constitution Day speech a few years ago. I suspect we were probably the only husband-wife team to do that. So last year, when the Arizona Supreme Court came here to hold oral arguments, and I suspect many of you were there for that, I was finally expecting to have Taylor freeze, and we actually flew in, and our security folks said, "Oh, it's not on the way to the airport." So I didn't get to have it. So finally, yesterday, thank you for that, and even more than that, thank you for the invitation to speak today. It is such an honor. And if anyone would ever ask me, would I drive nearly 200 miles for good ice cream? We now know the answer to that question. So what a beautiful, beautiful place this is. When we flew in last year, we were able to see some of the incredible scenery, but driving it is just so much more incredible. And I also want to thank the people in this room and the people in this community. Last year, my colleague Kate King and I were up for retention once again to the Arizona Supreme Court. We had the most vigorous campaign against us ever mounted against state Supreme Court justices, and we succeeded in winning our respective terms with roughly 58% of the vote statewide, but Graham County gave us by far our largest margin, 78%. So I am so grateful. And, thank you. If Justice King was here, she would thank you as well. This is also the first place I've ever been whose mascot is the Gila monster. And my wife and I moved to our current house, which is on the side of a mountain in Phoenix, about 11 or 12 years ago. And I was exploring outside and I'm like, oh my gosh, I think we have a Gila monster here. It was a very large, very colorful lizard. So I took a picture of it, posted it online, and found out it was not a Gila monster, it was a chuckwalla. Nonetheless, just actually a really delightful desert creature. We have a whole family of them living on our mountain. And I'm glad it wasn't a Gila monster because they are a lot more dangerous. But nonetheless, we've had so much fun with them. And one day, a UPS driver came by to deliver a package. She was halfway up our driveway and she starts shrieking. And she says, "You have a dinosaur living here." And sure enough, anyone who has experienced these desert creatures for the first time knows that we are the state that still has dinosaurs. So I think that you could not have a cooler mascot. I am also really delighted that Eastern Arizona College has transitioned to a four-year college offering a bachelor's degree in multiple subject matter. My wife was a part of that legislative effort. I was quietly pulling for her from the sidelines, and I just think that the growth of this college is just absolutely amazing. I want to make two other quick comments before plunging into to my talk today. First of all, from one judge to another, you all are so lucky to have one of Arizona's very best trial judges as your presiding and only Superior Court judge here in Graham County, Mike Peterson. He is absolutely fantastic. He is recognized and revered throughout the judiciary in Arizona. And the neat thing about Graham County is you have him all to yourself. So you are very, very lucky. And finally, I want to mention, some of you may be saying to yourselves, Justice Bullock, why didn't you wear a flag tie today or a Constitution tie? Well, if you look very closely at my tie, which was a gift from my staff a couple of years ago, you will see that it is a David versus Goliath tie. And our country's founding was the ultimate David versus Goliath victory. And our Constitution enshrines the principle of a level playing field, of individual rights that are inviolate against even the most powerful majority. So I actually wear this David versus Goliath tie on Constitution Day because I think that at its core, that is what our Constitution is all about. So I'm going to do something a little different today. 8 days ago, I was in Washington, D.C., and I gave a talk on the 100th anniversary of a case from that long ago. And I thought to myself as I was talking about that case, you know what? I think I'm going to talk about it again on Constitution Day because this case exemplifies the integrity, the endurance of our Constitution, the meaningfulness of our Constitution for the real lives of real people. Unless you are a constitutional law nerd like I am, or a history nerd like I am, you probably are unfamiliar with this case, but it's a very, very, in my mind, a very, very fascinating story and one that has resonance even today. It's a case, if you do your math, and my math is terrible, but I can even do this one, case from 1925. And it was, like so many U.S. Supreme Court cases, very emblematic of its times. In the late 1800s and the first quarter century of the 20th century, it was a time of tremendous nativism in the United States. You know, the South was primarily focused on trying to continue to subjugate the rights of Black Americans, but the rest of the country was very, very deeply committed to preventing immigrants from coming in, and if they did come in, to make sure that their rights were not fully honored. And this took so many different forms. But the one thing I will say about these particular nativists is that they were equal opportunity nativists. They hated everybody: Chinese, Mexicans, Irish, Italians, Eastern Europeans. And so they directed laws against all of these groups. Just to give you one example, a case that went to the United States Supreme Court in the late 1800s dealt with San Francisco's efforts to destroy the ability of Chinese immigrants to operate laundries in San Francisco, and the court struck down that law. But one of the things that most offended these nativists were that so many of the immigrants brought not only their foreign roots, but they brought with them their language, if they spoke a foreign language other than English, and their schools and their religion. And so they were bound and determined to suppress that to the greatest possible extent. There was a United States Senator named James G. Blaine who tried to get an amendment to the Constitution and failed. And these were called Blaine Amendments, and they were directed toward making sure that no funding would ever go to sectarian schools. When you think about that word now, sectarian is synonymous with religion. But in the late 1800s, sectarian meant The public schools were run by Protestants. They taught the Bible. They were often taught by pastors. And the idea that any money would ever go to support a Catholic school was anathema to Blaine. He failed in getting that amendment to the United States Constitution, but he succeeded in getting that amendment passed in roughly 2/3 of the state constitutions. Well, so there were all sorts of restrictions, and one of them that went to the United States Supreme Court in 1923 forbade the teaching of foreign languages in public schools except at the very, very highest grades. And a fellow by the name of Meyer was fired from his job because during recess he would teach German. And this case went to the United States Supreme Court in 1923 in a case called Meyer versus Nebraska. Well, the case that I am going to talk about happened in Oregon. And this is hard to believe considering how blue a state Oregon is right now. But in the 1920s, Oregon's politics were dominated by the Ku Klux Klan, of all things. And the Ku Klux Klan was, of course, at the cornerstone of this nativist movement, and they promoted a variety of laws designed to destroy Catholic education and independent education of all types. And so in Oregon, they succeeded in passing a law by voter initiative that required students to attend K-12 education in public schools only. So all private schools would have been driven out of business by this law. So a Catholic organization that had started a school in 1859 in Oregon, run by an organization called the Society of Sisters, wanted, of course, to continue their school, and they organized a lawsuit to go up to the United States Supreme Court, hopefully, and get this law struck down. Now, you would think, if you were thinking about a lawsuit of this type, it's a Catholic organization, that this lawsuit would argue that the law was a violation of the free exercise of religion, which is guaranteed by our First Amendment. But it wasn't. Why wasn't it? And this is an interesting point in history. Because by the early 1920s, the Bill of Rights had not yet been incorporated against the states. So the Bill of Rights did not apply to state governments. It began being applied or incorporated against the state governments with the free speech provision in the late 1920s, and that process didn't fully end until the Second Amendment was incorporated against the states less than 25 years ago. So the Bill of Rights did not apply against the states. So what could they possibly use? Well, they looked at the 14th Amendment and they found the protection of due process, that your rights to life, liberty, and property could not be violated except with due process of law. And they said, you know what? Our rights to liberty and property have been violated without due process of law. So they made their way up to the U.S. Supreme Court, and happily for them, the U.S. Supreme Court was beginning to vigorously protect the right to contract and other property rights and liberty rights at around that time. And in fact, Mr. Meyer's case went to the U.S. Supreme Court, and the court ruled that this was a violation of his freedom of contract. He was unable to contract with parents that wanted their kids to learn to speak German. So the case goes up to the US Supreme Court in 1925, and by this time, the nativists had another weapon at their disposal because there was a huge fear of communism called the Red Scare in the 1920s. Some of you have studied about Sacco and Vanzetti, and they argued in the US Supreme Court, and I'm quoting from their brief, if the Oregon school law is held to be unconstitutional, it is not only a possibility, but almost a certainty that within a few years, the great centers of population in our country will be dotted with elementary schools which, instead of being read on the outside, will be read on the inside. This is Catholic schools they're talking about. This is crazy. And yet, this was the argument that they made. They said, one flag, one school. Everyone should go to public schools only. So those arguing in the Supreme Court on behalf of the Society of Sisters decided to make it a two-pronged argument. They first wrapped themselves in the Meyer case and said, this is freedom of contract. But they also made a second argument, and this was the argument that ultimately became a cornerstone of American constitutional law, that parents, not the state, should have the primary control over their children's education and upbringing. Never before recognized by the US Supreme Court, but argued to the United States Supreme Court. Interestingly, I read in prep for my speech last week, I read a book about this case. I love the name of it because it's a double entendre. It's called Cross Purposes. And this book described as the lawyers were preparing for argument in the US Supreme Court, it turns out that you used to be able to have strategy sessions in the US Supreme Court in their conference rooms, which, would be so cool, but trust me, it doesn't happen these days. So they're meeting to prepare for their argument in the US Supreme Court, and who wanders into the conference room but Chief Justice William Taft. And he says, what are you guys here for? And they're like, we're arguing the Pierce versus Society of Sisters case. We were going to ask you for some extra time to present our argument. And he said to them, and I quote here, I don't see why you want any more time. In principle, this is simply the Meyer case over again. Boy, that's sort of like, seeing your judge at a grocery store, and the judge says, guess what, I'm going to rule for you this week. Definitely a good feeling, but it, again, doesn't happen anymore. But the case goes to the United States Supreme Court, and the court rules in favor of the Society of Sisters, 9-0. And the court upholds or strikes down the law under Meyer versus Nebraska, but it goes a step further. And I'm going to read from the opinion because this language is so important, and in my mind, it is so beautiful. The Act of 1922 unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children under their control. The fundamental theory of liberty upon which all governments in this union reposes excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Now, I cannot tell you how minority this viewpoint is in the world. Every country has a constitution. Most countries, the constitution is not worth the paper it's printed on. Go to China and burn a Chinese flag, and you're going to be introduced to jail immediately, even if they have a freedom of speech. Do it here in the United States, and you are unmolested because the court has held that that act is protected by the freedom of speech. So why talk 100 years later about a case like Pierce versus Society of Sisters? It is because that case is resonant today. Fast forward 70 years, my colleagues and I are defending school choice programs, school voucher programs in, as it turns out, 12 different states over a period of 16 cases in 12 states over the course of 1991 to 2003 when the US Supreme Court upholds it. The plaintiffs in these cases are arguing that these programs violate the prohibition against the establishment of religion. And they have got lots of cases on their side. We elected to argue the case differently. We said, this case is not about religion. These cases are about the rights of parents to control their children's education. See Pierce versus Society of Sisters, and about the right to an equal educational opportunity. See Brown versus Board of Education. In 2003, the US Supreme Court, by a less resounding vote of 5-4, upheld school choice and allowed programs like Arizona's Education Savings Account program and programs now across the country to continue and to flourish. This year, the US Supreme Court celebrated the 100th anniversary of Pierce versus Society of Sisters in a case called Mahmoud. And some of you have probably read about this case. It involved a Montgomery County, Maryland policy in their public schools to forbid parents from opting their kids out on religious liberty grounds from lessons that they found objectionable, specifically LGBTQ books that were part of the curriculum and that some parents disagreed with on religious grounds. Originally, the school district had an opt-out policy, and after a while they said, you know what, this is too much trouble to allow parents to opt out from lessons that they consider morally offensive. The case goes to the US Supreme Court. A Muslim family is the lead plaintiff in this case. And the US Supreme Court rules on the basis of Pierce versus Society of Sisters that parents get to control their children's education. And if a lesson offends their religious beliefs, they have to be allowed to opt out. So a case from 100 years ago continues to flourish today and to allow parents in the United States to have a degree of freedom that parents around the world would do so much to have for themselves. Well, just a few concluding remarks. I think this case really illustrates how important our Constitution is, that it really is a meaningful document, that in a court of law, David can beat Goliath, and does beat Goliath time and time again if the Constitution is on their side. This is something very, very much worth fighting for. Over the last week and the tragic events that we witnessed, we learned, if we didn't already know it, how valuable freedom of speech is. But there are so many other rights in our Constitution that we must not surrender. And I want to close by noting that You know, we are so deeply divided into blue and red America. We've had a number of changes in administration, and the presidents don't agree on hardly anything. But there's one thing that they all agree on, and that is that the U.S. Supreme Court is bad. Presidents don't like the Supreme Court because the Supreme Court often reins in what they do. So President Obama was very upset when his DACA policy was struck down as an executive order. President Biden was upset when his student loan forgiveness program as an executive order was struck down. I suspect that President Trump is going to be upset with the U.S. Supreme Court on a number of occasions over the course of this term. The thing to keep in mind is that it was a brilliant innovation on the part of the framers of our Constitution to create an independent body whose sole obligation is to the Constitution, not to the voters. The other two branches are responsible to the voters, but the court system is responsible to the Constitution. Do we sometimes get it wrong? Absolutely. But most of the time, they get it right. And if you see a reaction to a court opinion saying something like, this is killing our democracy, this unelected branch of government, keep in mind, as in the words that we just recited in our Pledge to Allegiance, this is not a democracy. It's a constitutional republic. And one of the main differences between a democracy and a constitutional republic is that there are some rights that we possess as individuals that cannot be violated by the majority or the government, no matter who they are, no matter how big the majority is. And for better or worse, at the end of the day, the framers said, we need one branch of government that takes the long view, not the short view of advancing a particular policy for momentary advantage or for momentary gain. And that is the courts. So, if you hear the president, this president or a future president, condemning the courts for a court decision, take it with a grain of salt. Because part of our constitutional system, an important part of our constitutional system, is that there is one branch of government whose fundamental role is to protect the rights of everyone in this room and everyone else, no matter how politically powerless those people may be. I hope you enjoyed the story about Pierce versus Society of Sisters. I hope that you all go out, and what I love about this college is how much it is working on instilling civic knowledge and civil discourse among its students. You are going to be the leaders of tomorrow, which actually gives me tremendous optimism. And I'm going to end this speech with words I have never ended a speech with before in my entire life. Go Monsters. Thank you.
I also say that, go Monsters. Thank you, first of all, for your remarks. On behalf of the ASCAC and for coming out, we would like to give you this gift basket with all the cool merch. And so the next time you come, you can wear the top. In conclusion, make sure you all get a box lunch on the way out and a little Constitution to study up on. And yeah, thank you all for coming. Another round of applause, please.